SwayamPrabha. Digital India. Educated India.
Welcome viewers, this is Dr. Ashwini Siwal from Faculty of Law, University of Delhi. I am here to discuss a very important aspect in this series called Law, Science and Technology. I am here to discuss lecture number 4 of this series called Law, Science and Technology, and this lecture is about 3D printing and the legal issues surrounding 3D printing. Well, my dear viewers, you must be wondering what this 3D printing is all about, and what are the legal issues that surrounds 3D printing. Viewers, there are many issues, many legal issues which revolve or which surround around this issue called or which surround around this topic called 3D printing. To name a few, there are many intellectual property issues. First and the foremost, there are intellectual property issues, then we have some issues pertaining to criminal liabilities or civil liabilities or taxation and so on and so forth. So, for students interested in the discipline of intersection of law, science and technology must understand this specific technology and the legal issues pertaining to it. My dear viewers, 3D printing is not very new technology, but you may say that neither too old or nor too new a technology. There are many and multifarious uses which 3D printers are used for, ranging from manufacturing or printing the manufactured goods, then printing the organs, even prosthetics, and printing even food. So, the use of the 3D printers these days are multifarious and many and multiple. So, with this background, I would like to give you detailed introduction to the concept of 3D printers as to how they work and what may be the possible legal issues that may occur while the use of the 3D printers by the entities, by the organizations or even by the individuals. So, let us see this issue called 3D printing and the legal issues surrounding it. Viewers, 3D printing is also called additive manufacturing. It is called additive manufacturing. It refers to technologies that produce 3-dimensional objects. You see, 3D, the word 3D is signifies or it is referring to 3-dimensional objects or 3-dimensional products. So, basically the technology is producing the 3-dimensional objects by depositing layer upon layer of material during the manufacturing process. The process starts with a 3D model or a digital blueprint for a physical object in a computer file. So, there lies an involvement of computer systems also while using the 3D printers, because a 3D model or a digital 3D blueprint is required of a physical object in a computer file. So, if I want to make say a mouse of a computer or a keyboard or a cell phone or for that matter any big machine like a car. So, I require the physical objects blueprint, and that blueprint has to be stored in the computer file. So, a designer may create a 3D model by using a computer aided design program that is called CAD. By this computer aided design program, the designer will make the physical prototype or can make the physical object, the manufactured object or he may print. We will not technically call it a manufacturing, we will call it a printing, but it looks as if it is a manufactured product or a manufactured good. So, this computer aided design program eliminates the need to make a physical prototype, and it rather comes up with the product directly. So, alternatively a 3D scanner may collect digital data on the object shape and generate the digital blueprint. There are 3D scanners available these days apart from the printers, which can create the object shape or create the digital object shape and generate the digital blueprint. A designer may alter that data and change some aspect of the scanned object's shape. When completed, a 3D model controls how a 3D printer applies successive layers of material to make an object. So, a 3D printer converts a digital blueprint into a physical object called a 3D print, and this 3D print can use a variety of materials: plastic, ceramics, metal, foodstuffs and biological tissues as well. So, this is quite interesting and fascinating that the mankind has the science has advanced to this level where the printers are used not just for ordinary printing. I would like to just inform you that printers or advent of the printing machines in the probably in the 16th century was in itself a breakthrough innovation or a breakthrough invention, which raised a lot of legal and ethical questions, but it was a mere photocopying or a reproduction of the papers or reproduction of the literary work which the printers were doing. But even post the advent of the printing machines in the 16th century, the laws were to be framed or articulated to address the concerns. Specifically, immediately after the advent of the machines, the guilds were formed, printing guilds came up, then statutes started coming up on tackling the issues of printing or the menaces that the printing or the invention of printing brought with it. Specifically, the reproduction became so easier, or copying of the literary work became so easier post the advent of the printing machines. And if I am not wrong, then let me tell you that it was because of the printing machines only there came some statutes in UK which catered to the aspect of copyright infringement. So, the discourse pertaining to copyright or the copyright infringement or copying basically is spearheaded, or you may say triggered by the advent of the printing machines in back in the 16th century. And that development did not stop there. The scientific development has expanded to the extent where we are having 3D printers these days, which are not merely printing, or which are not just ordinarily printing like a ordinary printer. Rather, they are printing the food, they are printing the limbs, they are printing the products in the form of machines or cars or mouses or anything they can print, because they have a computer aided program which just requires a digital blueprint of a something, and once that digital blueprint is given to a CAD program, it leads to multiple layering and printing of a particular digital blueprint into a physical object. But how this takes us to legal concerns and legal issues? What kind of a legal questions may arise because of this kind of a technology? Well, we will come to that, but let us have a look at the history of the 3D printing. It was invented by engineer Chuck Hull in 1986 and recognized by recognizing the value of additive manufacturing. NASA conducted the first 3D printing calibration test in space on November 17, 2014. So, they understood that 3D printing is a breakthrough innovation, and it requires further exploration about this technology, or there is a need of further exploration about this technology. That is why NASA conducted first calibration test in space in year 2014. There has also been a remarkable expansion in the area of bioprinting using this technology. When we talk about bioprinting, then apart from the legal, there are ethical concerns also which may arise, because bioprinting is something not so casual or not so normal. It is something beyond you may say humans intervention, or it is something different than an ordinary printing. So, on December 3rd, 2016, Google grant with IIT Bombay launched a project in the field of prosthetics to manufacture the conventional rubber based foot using 3D printing. And this is something which brings us to the ethical issues that might arise because of the printing of limbs or organs, or which in a small sense, or which in a small popular sense called is bioprinting. So today 3D printing is used to cater to the global need for prosthetics, especially in the developing countries where there is a lack of access and affordability, and these inaccessibility and unaffordability are the major obstructions for organ seekers or prosthetic seekers. So limbs are made by using the 3D printers, especially those limbs which do not require much compatibility, like hand or a foot or fingers, etc. So this 3D printer is not confined or restricted only to manufacturing some products or some manufactured goods. Rather, it is printing biological arms or biological legs or foot or hands. Now coming to historical background of 3D printing in India, in the early days in 1990s till 2000, the first instance of additive manufacturing in India or 3D printing in India can be traced back to the late 1990s, when global industries started exploring rapid prototyping. During this period, a few Indian companies and educational institutions began importing 3D printers. Initially, in Indian context, the importing started, or imports of the 3D printers started, but later we started making our own 3D printers. So the importing began in the 90s. The Indian Institute of Technology, Bombay, was among the pioneers for setting up an additive manufacturing lab to explore the potential of this novel technology. So we have had a lab in the IIT Bombay since the 90s, and IIT Bombay is the pioneer institute to have established a dedicated lab for the exploration on the novel technology called additive manufacturing or 3D printing. Then there arose a rise of domestic manufacturing or manufacturers post 2000 or in between 2000 and 2010. By the mid 2000, India saw the emergence of first domestic 3D printer manufacturers. Firms like Divide by Zero and technologies began offering indigenously developed 3D printers. So by the mid of the 2000s, we brought our own, or we have had our own 3D printers made by indigenously made by our own companies like Divide by Zero. Then Altum also challenged the market by bringing new machines, and they challenged the import. These machines primarily employing fused deposition modeling catered to the growing demand from educational institutions to small scale industries. The primary beneficiaries, or you may say takers of these devices were primarily the educational institutions like IITs or IIMs, and then some small scale industries. They started taking these machines as well as products or byproducts of these machines or the end products of these machines. So the horizon expanded post 2010, because 2010 is a significant year when there came a significant turn in India's 3D printing journey, or in India's additive manufacturing journey. The country witnessed a surge in startups dedicated to 3D printing, offering services ranging from prototyping to finished product manufacturing. Companies like Imaginarium, Think 3D and Sahas Softtech made notable strides in the industry. This period also witnessed the emergence of metal 3D printing in sectors such as aerospace, healthcare and automotive. So there is no sector which is untouched at this juncture of the 3D printing or its benefits. But simultaneously there are legal issues that may arise or are arising because of the use of the 3D printers. So one organization or any other organization using the 3D printers in any sector for that matter has to be very careful about some legal issues. primarily the intellectual property issues which I will cover and discuss today. The government of India recognized the potential of this technology and launched initiatives under the Make in India campaign to promote indigenous manufacturing and R&D in 3D printing. The establishment of the centers for excellence at IIT Hyderabad in 2017 and then Applied Research International in collaboration with Applied International Research Collaboration was a significant step in this direction. So, Indian government did not want to lose on or remain behind in the race so far as this new novel technology of additive manufacturing is concerned, and they started bringing new initiatives in the form of centers of excellence in additive manufacturing or establishment of such centers in different institutions across the country. Apart from that, they also emphasized on the need of 3D printing or the need of bringing indigenously made 3D printers under the Make in Bharat or Make in India campaign, and there came a surge of industrial applications of the additive manufacturing technique in the year 2020 or in the post COVID period, and these these years marked a key shift in India's 3D printers journey. This decade witnessed the rapid adoption of 3D printers across various industries propelled by technological advancements, decreasing cost and growing comprehension of additive manufacturing potential. Let me tell you that post 2020 the 3D printers are used in each sector like aerospace, healthcare and automotives, and even in the this thing what should I call it, telecommunications to a great extent. And the advantage of using this assistive additive manufacturing technology is the cost, basically they are cost efficient, and there is no requirement of moving to the places for making a particular product, or you may say making a particular item. You have to just command the 3D printer by giving it a blueprint of a particular object, and it creates the particular product in a physical object form. So, there is a decrease in the cost of transportation as well as expertise, and now 3D printers which are programmed or customed to do certain jobs, they are rather bought by the previous sellers, or you may say the end users. Now they do not rely on the manufacturing units or manufacturing organizations, and they do not have to wait for transportations of a particular product. Rather they prefer to buy the 3D printer and accordingly manufacture, or you may say print, I will rather say print the particular object or physical object anywhere or in any environment. So far as the intellectual property issues are concerned, well viewers, intellectual property is a field which is really very dynamic, because it has a bearing with every aspect of science and every aspect of science and technology. For example, we have in this lecture series seen that intellectual property caters to, or it has a bearing with robotics, it has a bearing with AI, it has a bearing with your biotech, nanotech, VR, AR. And it also has the bearing in the case of 3D printers, because you see, let me explain it quickly to you that what intellectual property protects, because there are viewers who I believe are not aware what does intellectual property protect and how does it function, and what are different kinds of intellectual properties which are important in the context of 3D printers for you to understand. Well, intellectual property is a regime, or you may say intellectual property as such is a property that is an offshoot of your intellect, which comes from your intellect. It is definitely given some concrete shape, or it is definitely fixed into particular format, right. It may be an expression, it may be a product, it may be a cinefilm, it may be a audio video, or it may be a, you may say, sound recording. It may also be a word, letter, numeral, logo, device, symbol, it may also be a design. And when it comes to design, so 3D printers which are using the blueprints are not the designs. So some such issues are going to arise or might going to pop up in the case of use of 3D printers. Moreover, when it comes to trademarks, like trademark law protects logo, device, numeral, or it protects the indications on goods and services in the course of trade. So trademark law also comes into the picture in the cases of 3D printers, especially if a 3D printing is being done of a product which has a particular trademark, or which is trademark protected product. So any such trademark protected product, if it is produced, now the gray area is, or perplexing question is, since the product has been created and the trademark does not lie on the product, it is on the goods or on the services, and by trademark or by the protection of the trademarks, the indication which is used in the course of trade is protected. It is not the goods which are protected, it is not the goods or their quality, it is not the goods or their material composition which is protected. It is the trademark or the indication which gets protected under the trademark law. So the argument that comes from the users of the 3D printers is that they are printing the products, or they are printing the particular goods. They are not replicating, or they are not in any way whatsoever replicating or reiterating or iterating the trademark in question. But my dear viewers, will not it be inconsistent with the idea of conferring a trademark on a particular good or a service? Because when a trademark is conferred on a good or a service, the idea behind conferring trademark protection is to ensure to the general populace and the end users of the goods or consumers that the product is basically a product which originates from a particular manufacturer, or the idea is to tell the source of a particular commodity. So and to great extent the idea is to ensure the quality also, though quality control in the case of a trademarks is a misnomer. It rarely happens that the trademark bearing goods will have the same quality across different licensees of a trademark or assignees of a trademark for that matter. But that perception about the use of the trademark with the particular good or a service to indicate not just the source or origin, rather to indicate some quality, reputation, goodwill, will get affected or hit if 3D printers will tomorrow create a product of a cheaper quality vis-a-vis to the original product bearing a trademark. Though they are not iterating the trademark as they are arguing, but in this case irrespective of they being creating or iterating the trademark, they are iterating the goods, or they are reproducing the goods, and once those goods are created, they look similar or deceptively similar or confusingly similar with the trademarks, or with the goods bearing the trademarks. So there may arise many legal issues pertaining to intellectual property, especially trademarks. And when we talk about other intellectual properties like copyright, we all know that copyright protects literary, artistic, dramatic, musical works, sound recordings, cinefilms, etc. And under the copyright law, the computer programs are also protected. The computer programs comes under or falls under the category of literary works in the case of copyright law. So when we talk about computer programs, as I told you at the outset that 3D printer basically revolves on the CAD program, or you may say computer aided program. So that CAD program requires a digital blueprint or a file of a particular object which is to be created. So when that file is fed into the 3D printer, the CAD or this computer aided program processes it and makes it into a physical object. Here you may claim that some copyright issues may arise, or some copyright issues are bound to arise, because in this case somebody's computer program might get iterated, or somebody's copyrighted work might get iterated. So, to look at the issues which surround computer programs, or sorry, copyright, let me give you the instance of software code, which is generally treated as a literary work under the copyright law. The CAD files may be treated as artistic works, since they may amount to a drawing including a diagram, map, chart or a plan. So, this computer aided file may be treated as an artistic work here. Additionally, 3D printing object may also amount to an artistic work if it is a sculpture, engraving or other work of artistic craftsman. So, it is also possible that 3D printing work may be a in this case art or a sculpture or a engraving, right, and when that artistic work or a sculpture or an engraving is iterated in a 3D printer, it is a work of artistic craftsmanship, and artistic craftsmanship is protected under the copyright law. So, infringement may occur when any person does any acts which are the exclusive rights of the copyright holder, like reproduction or import, and it is worth noting that Copyright Act expressly protects digital copies of the copyrighted work. So, it is also clear that copyright law protects not just the physical copies, it also protects the digital copies of the copyrighted works. So, any digital copy which is used under the in the 3D printer or in the additive manufacturing for creating some physical object, then it shall amount to infringement of the copyright. And there definitely will arise issues in the cases of industrial designs as well. When it comes to intellectual property, well, my dear viewers, industrial designs is a field of intellectual property where copyright in design is conferred on 3D or 2D or 3D objects or ornaments, or even on lines or configurations or on patterns, right. And the idea behind conferring the industrial design or copyright on a design under section 11 of the Designs Act is to primarily give the exclusivity to the owner of the design to apply it on the articles. It is the application right which the owner of the design gets. It is not the right on the article which he gets by the protection under the Industrial Designs Act. And there is a distinction, if you want to understand it, then the chair may be having a particular design, but that chair is not owned by the person who has created the design of that chair. It is the design which he owns, and the exclusive right of application of that design on a chair which he owns. Other people are free to come up with their own designs and apply to the particular product called a chair in this question. So, my dear viewers, the Industrial Designs Act is a unique act which or a sui generis legislation which basically protects the industrial designs, and in the cases of Industrial Designs Act, aesthetic of a end product or appeal of the end product is also very important. And in the 3D printers, any such designs may be iterated or repeated or copied, or technically speaking the piracy of the design may take place, and piracy under the Designs Act is an offence under section 22 of the Industrial Designs Act. So, any manufacturer or any maker by the 3D printers of any design must be careful that they should not use the design, and they must not apply the designs on the same articles. If they bring in the new application of the old designs, then it is okay, because as per the law, new application of the old design on a different article is altogether allowed, and no prerogative or no exclusivity on that new application of the non design or already existing design shall be given to the existing owner of the design, because it is the new application which one is bringing. So, with all these problems, 3D printers or the users of the 3D printers must be aware. Then apart from that, we have Patents Act, where the legislation on patents basically confers exclusive rights to the patent holders to prevent third parties from carrying on the act of selling, manufacturing, making of a patented invention over which the patent holder has an exclusive right. So, 3D printers may facilitate easier infringement of patents because they use CAD files, and these can be easily distributed online, which result or might result into products which can be printed easily at multiple locations with limited visibility of the patent holder. Now, since patent law protects products and processes, and products and processes protected under the patent law, basically the products in this case are susceptible to be infringed, because CAD files may be shared or communicated to anyone or easily distributed to anyone online, and the result of it is that the particular patented product may be replicated anywhere, and it may be just a simple product in the form of a say a pen for that matter, or a mouse for that matter, because both these are products. It may be a patented mouse if it has some such features which are novel, which are not obvious, which are of great utility, like this pen has got features to write on screens and to erase and to highlight things, etc. So, any such product may be printed by the 3D printers if they have the CAD files or the knowledge pertaining to that, and this may be done at any location irrespective of the visibility of the patent holder. Patent holder will never come to know that his products are being made or manufactured in this way, but when he comes to know, he may institute an action of infringement. Now, technically making of patented product constitutes infringement or tantamounts to an infringement, and this making may be a normal making or a making with the 3D printers. So, this will definitely amount to infringement. Further, the position on whether distributing of CAD files would amount to infringement of a patent is unclear and depends on whether making or selling digital iterations of the patented product constitutes direct infringement of the patent holder's rights. So, there are a couple of things which are not clear in the patent regime so far as the 3D printers are concerned, because CAD files or their distribution is something which might appropriately fall under the copyright law, because copyright law says anyone's work, copyrighted work, the computer program or any CAD file in this case, if it is distributed, right, if it is issued or if it is communicated, then it is the copyright law that comes into the picture, specifically section 14 of the Copyright Act, which reads that reproducing anyone's work without the permission of that person, translating, adapting or communicating it or issuing it to the public or distributing it to the public tantamounts to infringement of the copyright. And 51 of the Copyright Act also comes handy here. I must draw your attention to section 51 of the Copyright Act, which lays down many acts which constitute infringement, and it has enumerated many acts which constitute infringement, but there is no discussion or direct reference about 3D printers in either of these laws, either of the intellectual property laws, because it is something new. Moreover, there are no use cases of infringement of intellectual properties by the 3D printers which has come across or which are there. So, design I already explained. Now, coming to industrial implications, there are huge industrial implications across different sectors of 3D printing. The companies because of the 3D printers will be able to focus their attention on innovation and development rather than on manufacturing and distribution. The cost of production of goods will decrease as the cost of shipping and handling will be negligible. These savings would flow on to importers in addition to savings on import duties, as the importing process may be more economical, and the business model is comparable to sale of e-books. We saw that there came a great transition in the way we read and we acquire knowledge through books. Earlier there used to be only hardbound books. Now we have the concept of e-books, and these e-books can be analyzed with the CAD files here or with the you may say 3D printing CAD files which are not physical copies, which are e-copies. So, e-books often tend to be cheaper than their physical counterpart, as there are no cost incurred in manufacturing and shipping. But on the contrary, with the physical book there always lies a cost of shipping and manufacturing. However, the impact of this technology would vary, because 3D printers itself are very expensive, but the times are not far away when the 3D printers will become economical or affordable to the general people, or to the commoners in the country or in the world. Now, coming to another challenge, in the food industry, it poses certain implications. In the food industry, it has implications in the form of making the food itself. If you ask the 3D printer, or require the 3D printer to make a burger for you, it can make. Or if you ask the 3D printer to make some sauces or condiments for you, it may probably make it, because 3D printed food is seen as a welcome development in the culinary and technology space, as technology today provided unprecedented control over the shape, color, texture and nutritional content of the food. Machine made food is no longer just a fun of a science novel, rather it is reality. Using 3D printers like Foodini, BioZoom, consumers can now print out a burger. Even India has developed its own commercially available 3D printer, and the same can print out chocolates in unique shapes. So, look at the drastic development, or the evolution of the technology, wherein printer can print a food product. There some food safety standards and some food safety act or legislations may come handy here, because according to the definition of the word food under FCCA appears to be wide enough to include 3D printed food. So, the food printing is something which attract the Safety and Standard Act, Food Safety and Standard Act of 2006, because any food must come into the definition of the FSSA, but the definition appears to be too wide to include even 3D printed food. Pursuant to the food safety standard and the act pertaining to it, a novel food may not have a history of human consumption, and it is a food or ingredient obtained by new technology, and 3D printing food is innovative and does not have a history of safe use. It could currently fall under this definition of novel food, right. So, the food authority may at any time direct a food business operator who is using 3D printers to provide details regarding the history of use of the novel or modified ingredients added to their safety evaluation. So, it is something which is in the process of taking a concrete shape. It is not yet it is not yet developed to that level where food can be printed and sold, because food selling of food or categorizing of food requires authorization, or requires recognition under the Food Safety Act and some other acts, and this since this is food made by a machine, so which has never existed in the history, and nobody knows its safe use. So, it may be falling under the definition of novel food. Then we have a lot of its industrial application in the pharmaceutical and medical device industry. Specifically, it has revolutionized the growing Indian pharmaceutical industry or its needs. The 3D printing drugs can resolve supply chain efficiencies, allow healthcare practitioners to customize drugs to their patients' needs, and reduce waste by allowing pharmaceutical companies to manufacture exactly to demand. 3D printers can also make clinical testing of drugs and medical devices simpler and cheaper by allowing companies to make changes to drug composition or the specifications of medical devices just by changing the CAD file. So, you see in the pharma industry, where the drugs are made, where diagnostic kits are made, where medical diagnostic tools are made, 3D printers may help or has immense significance, specifically when it comes to the economies where pharma sector is not that great. India being hub of pharmacy or having adequate pharmaceutical infrastructure does not probably require such technologies, but many countries where the pharma is in shambles or pharmaceuticals is not that advanced. So, over there these kind of technologies may be used to customize or to decrease the cost involved into making of the drugs. Then in the defense industry also it has multiple usages. The European Union has released the report of a study commissioned with the aim of eventually deploying 3D printing technology in defense specific scenarios, while the US has already successfully operationalized 3D printing technology to print spare parts for nuclear submarines which are no longer manufactured by the original manufacturers. So, this is again interesting from the point of view of industry as well as intellectual property. The instance of US where US has allowed the use of 3D printers to make spare part of the submarines, and those spare parts of the submarines may be patent protected, but because of being obsolete, the companies might have stopped making those spare parts, but the country has USA has allowed the manufacturing of those spare parts. So, will not it violate on the intellectual property if there exist any? So, such concerns are valid and real, but they may have answers, because even those spare parts which the original equipment manufacturers are not making, the patentee or the patent holders or any intellectual property holders of those parts may assign it to the manufacturers who are using 3D technologies to make new parts or those spare parts. Even in India, Hindustan Aeronautics Limited, an Indian state owned aerospace and defense company, is using 3D printing to print components for the indigenously developed Hindustan turbofan engine 25. So, in our context, in the Indian context, our companies or some companies in India have started using the 3D printing technologies to print components for the Hindustan turbofan engines or indigenously developed engines, and these are state owned aerospace space and defense company like Hindustan who are doing it. Similarly, gas turbine research, defense research and development organization, that is DRDO, in their laboratories they are using 3D printers to build prototype engines for India's aircraft program. So, the use of 3D printers has started across different sectors and across different institutions like DRDO or gas turbine research establishment. So, we see that the industrial application of a 3D printer is huge and immense. There may be some tax implications which I would like to skip because tax implications are not that important so far as this technology is concerned, because since it has not, it hasn't come to that advancement where taxes will being levied or will be levied on the technologies or will levied on the manufactured goods by these you may say printers or by these additive manufacturing tools. So, when it comes to ethical issues with the all disruptive technologies like 3D, there are some ethical issues bound to arise. When it comes to 3D printing specifically of organs or we call it a bioprinting, there are many ethical issues like if we discuss few, these organs can possibly eliminate the need of source organ from live and deceased donors. Though this is not such a great concern, because there is a scarcity or real dearth of or deceased owners of some organs. So, even if it will eliminate the need of live or deceased donors, it is fine. In India, the Transplantation of Human Organs Act governs the retrieval, storage and transplantation process for organs. So, this THOA, that is Transplantation of Human Organs Act, will also be relevant here to be seen or to be discussed. Therefore, it may be likely that in future 3D printed organs will be regulated much like the other things are regulated currently under Transplantation of Human Organs Act of 1994. But the question arises that either the legislature does it by making the changes and including the 3D printed or including the additive manufacturing outcome in the form of printed organs or bioprinting organs into its definition. Otherwise, this act may not apply, but these are some ethical issues which may arise. Then some privacy issues may also arise, just the way online privacy it is compromised to a very great extent. Similarly, quite in a very faster way, the CAD replicas might be distributed and which may contain a personal data. Indeed 3D printers are often used to test surgeries. For instance, in such case the doctor will manufacture a perfect copy of the patient's organ in order to see whether during the surgery he will encounter any issue. So there lies a privacy threat in usage of the 3D printers in the medical sector, and there also lies a issue of piracy, because like an online piracy, copyrighted works are pirated or musical works are pirated, 3D printed works can also be pirated due to simplicity of printing out items protected by IP. The possibility of access and increase in the 3D printing of the copyrighted work or any other work of a IP holder proliferates leaps and bounds. So, the viewers, the point is that 3D printer, unlike a normal printer, has developed to a very great extent or is a great technology, but there are many issues which may arise so far as the many legal issues which may arise so far as the use of the 3D printers are concerned. Some of the legal problems or legal concerns which may arise, I have just discussed them briefly here. Most notably the intellectual property issues that may arise, and wherein I have discussed that 3D printers may be used for violating or for iterating the copyrighted works, patented works or trademark bearing goods, as well as industrial designs, etc. And it is also possible that 3D printers tomorrow may start making or manufacturing the layout designs and integrated circuits as well, which are also intellectual property protected. So, all these are intellectual property protected works which are vulnerable to the new technology called 3D printing, especially the trademark, because any trademark bearing goods can be now made at a home by any individual for a domestic use. Trademark law or copyright law or patent law or industrial design law, for that matter, they all provide some sort of exemptions or exceptions. When it comes to exceptions, for review, research, for criticism, for private use, etc., you may probably be allowed, or you may be legitimately be allowed to print anything by use of the 3D printers. But when it comes to public use, when it comes to its communication, transmission, distribution, or production, manufacturing, for selling, for offering it for sale, for importing and exporting, then it is problematic, and the act may tantamount to infringement of some of the intellectual properties. And similarly, industry applications are there of the 3D printers which we just saw. The most notable are in the pharmaceutical and medical industry, which has the threat of even replacing the live or human donors in terms of bioprinting or in terms of the organ printing. Moreover, I have also discussed with you that it may have some tax implications, but the tax implications may arise only when the particular product falls into the ambit of taxes to be levied on it. Well, so far as this thing is concerned, any manufactured good, if it is being sold or if it is offered for sale, then some taxes will apply, And when it comes to private use of a 3D printed material or a 3D printed object, then I doubt that it may have any kind of a tax liability. But when you offer it for a sale, or when you by creating a 3D product, you let it into the market for sale or float it into the market for sale, and you enter into a course of trade, then taxes will definitely be levied. Though the regime is not clear, and I have not come across whether the taxes are applicable on the 3D printing objects or not, though technically when the 3D printed objects are floated in the market for sale, the taxes must be levied as as if they are the goods which are manufactured in the manufacturing units by the respective owners of, or by the respective traders, right. Then coming to some more interesting things of the 3D printing, especially in the healthcare. The hospitals require patients for a privacy consent to the 3D printing of their organs, and what happens to that the 3D printed organ, after the tested surgery, it might be used for research, but might be even made available to third parties that through the information contained therein might perform direct marketing activities to his benefit, or even change the insurance policy premium. There are still a number of open questions on 3D printing, and as frequently happened in relation to any new type of technology, legislators and courts might not be fully prepared for them, but we need to be prepared for the answers to such perplexing questions of 3D printing, and specifically in the context of the courts and the legislators. I will say that they must think futuristic, and they must bring some law, or at least in the current regimen on intellectual property, some mention of 3D printing must find a place, so that the readers, or the particular beneficiaries of it must be aware that intellectual property of a 3D printed product may be infringement, or may constitute an infringement in the case of they being printing the 3D printer, they being printing the products from the 3D printers. Then coming to the liabilities in the case of 3D printers, there may be civil as well as criminal liabilities which may be imposed. So far as the civil liabilities are concerned, the civil liabilities may float from Indian Contract Act, which is based on contractual relationship, then Consumer Protection Act, then Sale of Goods Act, Law of Torts, special statutes relating to specific goods like foods and pharmaceuticals. With 3D printing technology, the consumer is the manufacturer. The raw materials used by the consumer are the CAD file and the ink, while the 3D printer is the device used for manufacturing the desired product. So, I used to be earlier a consumer, but now I have become a manufacturer with the technology of a 3D printer, and I can print things at home, and there is no check or there cannot be any check on me as to how many copies I am printing. I may tomorrow sell those copies in an open market, irrespective of the fact that they are intellectual property products of somebody else. So, given that traditional legal definitions do not take into account the paradigm of 3D printing, it is unclear who will be liable in case the 3D printed product is defective, and this is another concern. Then whose liability shall it be if the product turns out to be defective, which has been sold in the open market but made by a 3D printer, whose civil liability or any other kind of a liability may be fastened. In the ordinary case, if the product turns out to be defective, or if it is found defective, the manufacturer bears the loss, or he has to pay the damages according to the Consumer Protection Act, or according to the Sale of Goods Act, as well as according to the Contract Act. But here liability can be entirely on the part of the maker of the CAD file, the maker of the 3D printer, the manufacturer of the ink, etc., and the liability can also be apportioned between either or all of the above parties. So far as the Indian courts are concerned, to our knowledge, they have not had the opportunity to lay down principles for apportionment of liability in case of 3D printed products, or you may say apportionment of the civil liability in the cases of 3D products. Then there may be couple of criminal liabilities. The criminal liability or the rule in criminal liability runs through the mens rea, our concept of guilty mind. Therefore, manufacturers and distributors of 3D printers and authors and sellers should ensure that their intent that the machines and files not to be used for criminal purposes is clearly communicated, right. So, this is something based on malice, or you may say based on a malified intention. The 3D printers may also be used to make currency and stamps, which is again an offence under the Indian Penal Code, making counterfeit currency or stamp, etc. Or banknotes. There may be offences related to documents and to property marks. There are a lot of things which are protected under the scheme of the IPC in section 497 or 491, or so on and so forth, where property marks are protected. So, 3D printers can aid the making of a seal, plate or other instrument for the purposes of committing forgery of property marks, valuable security, wills, etc. And 3D printers can also be used by people to falsely represent 3D printed goods as something they are not, and in doing so deceive someone. So, cheating case may also be attracted, or 420's case may also be attracted, but with the new Sahitas, that is BNS and other criminal laws, we will see which provisions will get attracted. So far as the current regime, that is Indian Penal Code, is concerned, cheating offences or property offences may get attracted. So, to conclude, I will say that this 3D printing has vastly different effects on different industries. 3D printing technology is expected to have an overwhelming positive impact on pharma, on food industry in the future, while potentially presenting new challenges so far as the IP rights are concerned. Nonetheless, 3D printing technology is still in its nascent stage, and currently it is not affordable for regular households. However, if the technology improves and the cost decreases, we may expect that it becomes accessible and affordable. It can also help reduce waste and associated environmental impact. It also helps in cutting down the carbon footprint, etc. And 3D printing, much like the internet, could vastly improve life as we know it and irrevocably change it. So, as the technology plunges society into constant dynamism, it is up to the legal regime to rise up to the challenge, that is 3D printing. So, rising up to the challenge of 3D printing requires a lot of brainstorming and technical expertise, which the lawmakers as such or per se do not have, but they involve the domain experts, and accordingly they may make the laws and rise up to the challenges that the 3D printing is posing. With this I conclude this lecture, but I look forward to meeting you again in few more interesting talks in this series called Law, Science and Technology, wherein we are covering or looking at and exploring the intersection of law and tech. The interested students in the field of law and tech are most welcome to have a look at all these lectures, and I open for any kind of questions or queries or interaction with you through my email, etc. My dear viewers, I look forward to meeting you again. Thank you very much.